Judge Meadows, I'm guessing, took the view that exclusive dealing is never competition on the merits. And that's just wrong. There's cases that effectively say that it is, and it certainly is if the distributors want to deal exclusively and you just make the best offer. Making the best offer is exactly what we mean by competition on the merits.
Yeah.
And there are cases like this already been decided that should have been precedent that convinced Judge Mehta, but he just couldn't get around that this was exclusive dealing. Exclusive dealing is bad.
Yeah.
The second error, I think, was jumping to the conclusion that exclusive dealing necessarily produces an anti-competitive effect. In legal terms, the issue here is what's called causation.
Yeah.
So Judge Mehta looks out on the world and he sees that Google's rivals didn't get distribution and Google did. And he says, well, Google says that the government has to prove that the exclusive dealing caused that. And he says, no, they don't. They don't have to prove that. And I think they did. I think it's exactly what they had to prove. And if they didn't have to prove that, and still failing to prove it means they're not entitled to any of these behavioral remedies that are what could really matter here. Google's willing to not deal exclusively because it agrees with me that it doesn't need to deal exclusively. Contracts don't have to say you must deal only with me because they're going to deal only with Google. So I think that these are not fine points. They're fundamental points of law. Judge Mehta made errors on both of them. And if Google argues these points in the Court of Appeals and draws a decent panel, then you never know what you're going to get. Then the odds are heavily in their favor that they will win on liability in the Court of Appeals.
Wow.